However, as soon as it's determined that it's going to be more than a year, even if it's on day 2, any money you receive for lodging or free lodging is
now taxable.
Taxable.
And with 3-year treaty NAFTA visas, the presumption is it's now the more than a year.
Well, especially if it's a 3-year visa.
So
and
you don't.
It's,
so
an indefinite employee
in
contract.
the old,
they just hired you as an employee. It's
well,
not a term contract.
Yeah, and well, a TN visa though was considered a term contract because it could only be for a year. The employment offer was only for a year, and there's all sorts of cases where if an employee his TN visa was not renewed, and that person went back across the country, went out of the country, that they had no claim against wrongful dismissal or being fired or loss of job or anything else.
Understood.
Yeah.
But we both know now it's 3-year visas.
Yeah, so it's 3-year visas.
All 3, both Canada's side and the U.S. side, because they were just wasting too much paperwork, I guess, renewing everybody.
So that's going to go away now from any presumption that what they've got is a temporary apartment.
For the 1-year rule, right?
That's right.
Now, there's still, the TN is technically a non-immigrant intent visa.
Yeah.
However, you and I both know there are cases where people with TN visas do file for change of status, meaning apply for their green card.
Well, they get it, but if they do that, they better never cross the U.S.-Canada border or the U.S.-Mexican border.
That's
while
right.
they're in that position.
After they send in that paperwork, their intent has changed. Therefore, they no longer qualify to get a new TN.
That's right. So they better not cross.
However, they can stay here on the one that they are on.
No.
And like you said, don't cross the border.
Well, they have to recognize that every time they cross the border, the INS or the Homeland Security agent or officer has the right to re-qualify them totally.
Exactly.
Yeah, okay.
And if they ask you the question, is it your intent to
Well, they've got it in their computer. They have it in their computer.
Right.
But the application's gone in, and they just send you away.
And if you say no, and they see it in their computer, they're not very happy.
No, then you've lied, and they take it away as well.
That's right. There goes your application and possibly any chance of ever getting one through.
Okay, so let me get this straight again. If you are in the States and you've been paid corporate to corporation, as it were, your position and my position has always been that whatever you got paid should just be reported to the U.S. And are we going to charge them CPP because they got paid from a Canadian corporation, or are we going to charge them Social Security because they were working in the States as an employee?
Well, my position is that the employee would be a resident, and I'm assuming that it's going to be a U.S. resident that owns a Canadian corporation.
Yeah.
Therefore, if the person is a U.S. resident, their responsibility will be to pay U.S. Social Security first.
Yeah.
And in the few cases I have, Bombardier, for instance, in their contracting, there's nothing wrong with the way they do it, but it can end up that you end up with a resident of Arizona billing Bombardier U.S. through his Canadian corporation. What I've done in that particular case is issued a T4 for the person and opened a U.S. payroll account and issued a W-2 and used the Social Security as opposed to and Arizona unemployment and follow the state rules for employees.
Okay. No, the corporation's paying the unemployment. The employee's not deducting it as it happens to us in Canada.
Right. In the U.S., there's no employee share of unemployment.
Okay.
And it's not a fixed rate. In many cases, it's just dependent upon how many people have left and claimed against you specifically. My rate could be 2.6% in Texas today. It could be 5% if my only employee quits, and that looks like I have a 100% turnover rate. Mm-hmm. My premiums will double.
But if your employee quits, it's not the same either than if you lay them off.
Well, Texas is one of those no-fault
Well, it doesn't matter in
states
Texas.
where pretty well an employee has no rights.
Because it does matter in California. I know I've actually got a client in that problem right now with the of the definition of whether they quit. Their TN visa expired, and the fellow wouldn't renew it, so the client had to come back to Canada, and California then ruled that he had quit the job and come back to Canada because the wife of the owner of the company said, well, he quit. He left 2 weeks early, and of course, when your TN expires, you're supposed to leave that day, technically.
Mm-hmm.
So he left a couple of weeks early, and as a consequence, California turned him down for unemployment insurance, even though he was, in my opinion, clearly entitled to it. So these are a whole bunch of other factors that take place.
Well, yeah, you read things, and technically you can be a resident of Canada collecting unemployment from any one of the individual states.
Oh, absolutely.
Normally qualified. I have never seen that.
Oh, I have. I've got lots of. One of my newsletters deals with that. I'll try and remember to send it to you again.
Okay, but that's because I'm not there.
Yeah. Well,
I don't do people who are residents there. I have many people who are U.S. residents, and they're for months and months, 8 months, still getting Canadian employment insurance.
Yep.
They're here on a TD visa.
Yep.
Cannot look for work even because their visa requirement, or it could be an L2 without work authorization, an H4, whatever. They're just the spouse, and they can't work. So there's some issues with employment insurance.
Well, I'll send. I did do a newsletter on that, and I'll try and remember to send you. If they make a note, Mitchell, to remind me to send them that one. It's the out-of-country unemployment insurance, and every state has a different agreement with Canada because they actually have done agreements. I got one more question to add, one more thing I want to touch on, because we talked about the temporary employment, and I agree with you that if it's for less than a year, but my understanding of that is that that only applies if I'm already working for the company and they send me to that other place. Can it apply to a new employee?
Well, we were talking in the context of Canadian citizen, U.S. resident who was working for his own corporation in Canada.
Okay, so
I'm making the assumption, that he had been working for his own corporation before he came to the U.S. on the TN.
Okay, so I see where that's coming from. Yeah. Secondly, then, on the same net, if you have a fellow that was paid on a 1099, and he's working for a Boston company and takes a job in New York, he isn't entitled to anything temporary, is he?
No, I don't believe so.
But they're all trying to do it, and that's the rumor going through the community of 1099 guys, that's what they should do. Okay, can I tackle another topic with you?
You could try. I may not have any answers, but you can always ask.
Well, if you don't, Gary, then our audience...
I never hesitate to say I don't know, because I don't know it all. That's something I readily admit.
Okay. Let me just find. It's an LLC and Canadian. I got to find it. You're not watching what I'm doing here. I'm going through a list of questions that have come in because I told people they had to email me a question if we were going to do this. And one of them came in talking about setting up an LLC. Here we go. I am starting or founding, this is a Canadian resident, okay? And he says, I am founding a startup with an American investor. The investment will be placed in a Texas-based LLC unless I can suggest something better. The U.S. LLC will open and fund a Canadian subsidiary for product development. Whoever
it will own a Canadian
That's right.
subsidiary?
That's what it says.
Okay.
Okay. All operations and sales will occur through the U.S. LLC, i.e. no revenue through the Canadian entity, only expenses. I mean, does this sound like crazy? I will be an employee of the Canadian subsidiary, but will have an ownership stake in the U.S. LLC of less than 25%. He wants to know, will I be double taxed in any dividends or capital gains of the LLC? Is there some ownership structure that I can personally implement to avoid that? I am a Canadian citizen and resident. Now, I hate it when a Canadian has a U.S. LLC. Have you got any comment on that?
Well, it's a lot cleaner now with the new treaty.
The new treaty is, yeah.
Prior to this, we had major problems on S corporations and LLCs because of the flow-through treatment in one country and different treatment in another country.
Yes.
You know, however, now, and you could, if it was an S corp, go through competent authority and get flow-through treatment. You could not do that with an LLC. Since the treaty, if it's transparent in one country, then they're going to allow it to be transparent in the other country. An LLC, by default, is a partnership if it has 2 or more members.
But you can file a form and make it a corporation.
Yes, but you can choose to elect under the what they call check-the-box rules.
Yes.
File a form and make an election to be first a corporation and second, typically at the same time, an S corporation.
Yeah.